Good morning, everybody. Thank you for being here today. We're going to be reviewing the Florida as-is contract. I'm going to share my screen in just a second here. Okay, so we're going to be reviewing every clause, and we're going to talk about some of the highlights and review every page individually. So some mistakes that people make and just some things to be aware of is that calendar days are never business days. The effective date is the date the documents are delivered to the final party. Day 1 begins the day after the effective date for the remaining deadline. And weekends and holidays. If a deadline besides the effective date ends on a weekend or a national holiday, it will extend to the next business day. Conventional or cash contingencies. There is no appraisal contingency built in. You will have to add one. And with FHA and VA, it is in the addendum. Never let the loan approval or commitment deadline pass without advising the list agent of the buyer's choice moving forward. Otherwise, the buyer defaults to no finance contingency with the deposit unprotected, and the seller can cancel on the buyer if they haven't heard from them. This is the number one missed deadline for why deposits aren't returned. So the as-is contract versus the residential contract for purchase, there are some major differences. The as-is contract has an inspection period where you can cancel for any reason for a deposit refund. The seller is not obligated to make any repairs or give any credits, but the buyer can request it. The seller isn't obligated to spend any money to close or rectify permits, but is required to assist with any needed access to the home and documentation. The residential contract for purchase and sale has an inspection period, but you cannot cancel just for any reason during it. It has a predetermined general repair, mold, termite, and permit repairs monetary limit that the seller is obligated to perform or pay up to a certain predetermined threshold for each. The default is 1.5%. The seller is obligated to spend a predetermined amount of money on assisting to close out or rectify permit issues. All right, so line 1, page 1. Here you're going to put the names of the parties, the seller and the buyer. The seller's name must match the deed, which can be found on the county property appraiser site and the county clerk site. All sellers must sign, even if a spouse is homesteaded and not on the deed. If it's an estate or corporation, signing rights can be given to one person. Line 2 for the buyers. Same thing as for the sellers. On the contract means they will be on the deed to the property. So if you put that person's name here, they will then be on the deed to the property. So just be aware of that. This doesn't mean they have to be on the loan. So just something to know. They can be on the deed, but not on the loan. Section 1 covers the property description. So here you don't want to abbreviate or leave anything blank, and don't go by the listing. Tax office ID and short legal. This is all going to be on the county appraiser's site. All right, personal property. We have included and excluded. So the included, the defaults are going to be listed, and you can add anything additional like washer, dryer, microwave. And then for the excluded, you're going to add anything affixed that needs to be excluded. So that would be something like the Nest thermostat, the Ring doorbell, the fridge, something like that. Section 2 covers the price and closing. So the price is going to be based on the comparative market analysis that you provided and competitiveness, but ultimately it's up to a buyer, and of course it doesn't have to be the list price. The deposit amount, the earnest money deposit needs to be given to title within 3 days. 1% is typical for an earnest money deposit, and 99% of the time it is going to be given after the contract goes into effect. And the escrow agent, so you're going to put the company name, not the individual agent. And you're going to also add the address, the phone number, and the FREC requirement. The escrow agent is the person who holds the deposit. Dalton Wade doesn't hold escrow funds. And it doesn't have to be the title or closing company, although usually it's the same. Any additional deposits are not required, but if used, typically that's going to be submitted after the last day of the inspection period. And Section 3 covers the time for acceptance and the effective date. So the time for acceptance is 24 hours. It's pretty typical, except if left blank, except if it's bank owned or if it's a multiple offer situation. If it passes and the seller is still considering the offer, you should initial changes to this when they send the counter offer back. Section 4 is going to be the closing date. You don't want to write on or before X date. If you need to change the date, you can just make an addendum and change it later. So you want to put an actual date there. Section 5 covers the extension of the closing date. So the closing date can be extended without an addendum in 2 circumstances. Otherwise, you have to have a signed extension. So the first circumstance is with if lender funds are not available, but the loan approval is complete. And so that's not to exceed 7 days. The other instance is force majeure, in which essential services aren't available, and that can be extended per Section G. Section 6 covers occupancy and possession. The buyer will get occupancy at closing. There will be no tenants left over or pending, no personal items left, and the keys will be delivered. If there are tenants left over at closing, 6BI should be checked. And the lease terms for the current or future tenants will be given to the buyer within 5 days of the effective date. The buyer can terminate within 5 days of receipt. Section 7 covers assignability. Contracts can be assigned to other buyers once this buyer is under contract. The buyer can sell the contract to a new buyer for a higher price and be released of their obligations. The buyer can sell the contract to a new buyer but not be released. If the new buyer can't perform, they must still purchase or lose the deposit. So you're going to check which one applies here. And the last option is that they may not assign it. And this is going to be the most typically chosen option. And it's usually for primary or secondary residences. Section 8 covers financing. 8A is cash. So there's no finance contingency, which also means there's no appraisal contingency. The buyer still can get a private appraisal, but they must add an appraisal contingency addendum for that to matter and to happen. The buyer can also still get a loan. There's just, again, no finance contingency. 8B is if the property will be financed. The loan approval default is 30 days. Approval means that the lender is willing to give a loan of X type at X rate to this buyer with a satisfactory appraisal already back, as long as the listed remaining pending conditions are satisfied by close. So there's no appraisal contingency with a conventional loan. This section talks about if the lender thinks the appraisal is satisfactory enough to get the loan. It doesn't talk about what the buyer thinks. So if the buyer is putting down 100K and the appraisal falls a little short, it's fine for the lender. So different loan types: conventional, FHA, VA, USDA, and of course, the others, which are usually private loan or seller financed. There's different rate types and interest types. Rates on pre-approval are slightly higher, usually to give some room. The default will be the buyer's credit worthiness. There's different loan terms. And for the loan application, it's a great idea to already have this part done. If it's not done yet, the default will be 5 days. All right, and then the loan approval period deadline. There are 3 buyer options, and then there are seller recourses. So if the loan approval is obtained by the deadline, the buyer must notify the seller in writing by the deadline. And texting doesn't count, so it has to be an email to the list agent. If the buyer is unable to obtain a loan or to obtain loan approval by the deadline, but is satisfied they will still be able to close regardless, they must notify the seller in writing by the expiration date, waiving their finance contingency. This will leave their deposit unprotected. If the buyer is unable to obtain a loan or loan approval by the deadline and knows they won't, the buyer may terminate the contract by delivering written notice to the seller by the expiration date, and the buyer will get their deposit refunded. Now, seller recourse. If written notice is not provided to the seller by the deadline, the seller can elect to terminate the contract by delivering written notice through email to the buyer's agent of termination to the buyer within 3 days of the expiration of the loan approval period. So if the buyer isn't in default, they will get their deposit back. Otherwise, the seller elects to move forward and wait it out. If the buyer has provided written notice of moving forward with or without loan approval, and then does not close, the seller will get the deposit, unless failure to close was something to do with the seller or the property. Section 9 covers closing costs, fees, and charges. So costs to be paid by the seller. You're going to see the contract for the extensive list, but it's in general the owner's policy, the title search charges, municipal lien search, if the seller is selecting the title, and then other, if applicable. Sometimes we see a fee that you charge your client here. Be careful of this because agents technically are not parties to the contract. Really, this should be in a transaction fee disclosure to the list agreement. So costs to be paid by the buyer. See the contract for the full list, but if it's financed, typically it's going to be taxes, recording fees on the mortgage, the lender's title policy, and the loan appraisal fees. Title, evidence, and insurance deadlines. So if cash is checked, the title commitment is going to be 5 days prior to close. If financed, it's going to be 15 days prior to close as the default, or you can write in a different number there. A title insurance commitment must be issued to the buyer from title. And if the seller has a prior owner policy, they need to furnish that within 5 days of the effective date. Municipal lien search. This is going to be unrecorded liens from the city, state, or county governing bodies. Some title companies will order from a search company that includes permits and codes in the municipal lien search, but not all do this because title technically can still pass with open permits. So you're going to want to ask title for a permit and code search. Turner Title, however, will do this automatically. So who picks the closing agent? If the seller picks a closing agent, they will pay the buyer's owner policy charge. If the buyer picks, then they will pay their own owner's policy charge. So this is going to be common in Dade, Broward, Sarasota, and Manatee, and then everywhere else, usually the seller will pay. And then the survey. So this is going to show all of the property boundary lines, the utility easements, encroachments, dwelling size, etc. Fee simple homes are going to have a survey, only fee simple homes. And if the seller has a prior one without changes, they must furnish that title within 5 days of the effective date. And if title can use it, They will, if they have to find a new one, they'll do that, but it's better if one doesn't have to be ordered. Home warranty. This is going to assist with mechanical systems and built-in appliances. Either the buyer or seller can pay for it. You're going to pick a cost maximum that it will cost whoever the paying party is, and the buyer or the seller can choose the vendor. We have special assessments. This is going to be public body imposed liens. Option A is going to be that the seller will pay in installments due prior to close. And this is obviously best for sellers. Option B is the seller to pay the assessments owed overall in full prior to close, which is, of course, better for the buyer. Section 10 is disclosures. We have the radon gas and mold, which are naturally occurring, but can cause harm if it builds up in dwellings. And this can be tested with, using a licensed inspector. We have permits. So unless disclosed, the seller doesn't know of unpermitted work or unclosed permits. And if unpermitted work is found, the seller must furnish all knowledge and documents they have, even though they're not required to spend any money to rectify it. The flood zone and elevation certificate. The buyer should verify by elevation certificate which flood zone a property is in. If the property is in a flood zone and the lowest floor is determined to be below elevation, or it's ineligible for flood insurance coverage, the buyer can cancel with written notice to the seller within X days, the default is 20, and get their deposit back. The energy brochure. This is where the buyer is acknowledging receipt of the energy brochure. Lead-based paint. This is for all properties built before 1978. The paint could be harmful if there is lead in it, all of the paint in the house. So please include this addendum and all of the lead-based paint info and the pamphlet. Make sure everybody signs that. We have the property tax disclosure. So this is going to cover change of ownership, which triggers reassessment, and that will lead to higher taxes. And then FERPTA. So the seller must advise the buyer in writing if they are a foreign person. The seller might have to bring extra cash to close if the proceeds are not enough. And the seller disclosure. The seller knows of no material defects except as disclosed in the seller's disclosure. Section 11 covers property maintenance. The seller is to maintain the property in the same condition throughout the contract, and that includes the lawn, the pool, and just everything on the property. Then we have the inspection period and the cancellation rights. The buyer can conduct any inspections they desire during this time. The default will be 15 days. Inspections, though, are never required. So typical inspections are going to be home inspections, septic, termite, and then VA and FHA will require mold. In the buyer's sole discretion, if the property is not acceptable, they can cancel. This must be done via a signed cancellation addendum that needs to be emailed to the listing agent in order for the deposit to be refunded. If it's not canceled, then the buyer is accepting the physical property condition as it is. Walkthrough and final inspection. So this is where you'll confirm that all items are remaining that should, all of the seller's belongings are gone, and that the seller has maintained the home appropriately. Usually this is conducted a day or a couple days prior to close. Please don't close if there's an issue. You can renegotiate anything that needs to be renegotiated with in a separate written addendum, or with escrow money from the seller's proceeds. Then we have the seller assistance and cooperation in the closeout of building permits. If the buyer finds open or needed permits, the seller must deliver all knowledge pertaining to it and will cooperate with the buyer if they wish to correct such issues. The seller is not required to spend any money in doing so, and permits aren't required to be fixed. Title can still pass. The assignment of repairs, treatment of contracts or warranties. If the buyer wishes, the seller will assign all maintenance contracts, warrantyisms, etc., to the buyer at closing. The buyer will pay any transfer fees. Section 13 and 14 covers the escrow agent and the broker. And this whole section survives closing. The escrow agent, title company, or attorney's office agrees to deposit its funds promptly and hold them in Florida, abiding by contract terms. If a dispute arises, the escrow agent agrees to disperse according to the signed written party agreement. And professional advice, broker liability. The broker advises buyers to verify property condition, square feet, facts, representations, and consult professionals. All representations are based on the seller and public record. The buyer and seller agree to hold harmless the brokers and their agents for certain situations. All right, this is section 15 to 17, so this covers the default and dispute resolution. So if the buyer fails, neglects, or refuses to perform, the seller can A, release the deposit back to the buyer and release them of further liability, or B, the seller can give back the deposit, cross out the section on the release and cancellation that they don't release the buyer of further liability, and they can sue for additional damages if they want. Or C, the seller may not give back the deposit and sue the buyer for damages in excess of the deposit. If option A is checked and any of the deposit is paid to the listing broker, it must be split evenly with the buyer's agent. If the seller fails, neglects, or refuses to perform, the buyer can A, get their deposit back and sign the release and cancellation, releasing the seller of further liability. Or B, the buyer can take their deposit back, sign the release and cancellation, but cross out the section about releasing the seller of liability and sue for additional damages. Or C, the buyer may sue to force the seller to sell. We have dispute resolution in section 16. So the first step is going to be to try to resolve any issues between the parties on their own. And the buyer and seller will have 10 days to try to do this. Step 2 will be mediation. And that is where an impartial third party assists the disputing parties to resolve the conflict and come to a mutually agreed upon agreement. And then step 3 will be arbitration. And this is where an impartial third party hears the cases from both sides and then they make a final binding decision. And then the last step is going to be in injunctive relief, where a court order will require one party to comply. So this is like litigation or in a lawsuit. Obviously, you can move straight away to a lawsuit, which is step 4, but it's the most costly and the most uncommon. The buyer and the seller will equally split all of the mediator fees, but each party will pay their own attorney's fees. And if it moves to litigation, the winning party is entitled to recover the costs associated with the attorney's fees from the losing party. Section 18, transaction standards. Title commitment shall be delivered to the buyer, and this shows matters that the seller has to settle prior to close, so the buyer can have a clear marketable title with ownership transfer. The buyer has 5 days after title commitment receipt to advise the seller of defects and let them know what they want cured. The seller then has 30 days to cure the title. If the seller cannot cure it, the buyer can extend the cure period. They can either accept it as is, or they can just cancel the contract and get their deposit back. B is the survey. If encroachments exist on a survey, the buyer should deliver the survey copy and written notice to the seller within 5 days of receipt and advise what they would like done. Ingress or egress. The seller represents that there is a legal right of access to and from the property. And then D is the lease information. At least 10 days prior to close, the seller will give the buyer estoppel letters from the tenants, and the seller could furnish the information informally with an affidavit, and the buyer has a right to contact the tenants to confirm all of the information. And then liens. The seller will furnish an affidavit stating there are no current pending liens on the property and no improvements within the past 90 days. If there were, the seller delivers releases, waivers of construction liens executed by all contractors, and a lien affidavit naming the contractors and stating that everything has been paid or will be paid by closing. And then F is time is of the essence. So if a deadline besides the effective date occurs on a weekend or national holiday, it will be extended to the next calendar day, and there are no more 5 p.m. deadlines. Force majeure is a force of nature, like a hurricane, some sort of storm, flooding, etc. If this affects the ability to perform or affects services essential to closing, the buyer and seller will not be forced to perform their contract obligations. All subsequent deadlines extend up to 7 days after the day the force majeure no longer prevents performance. If the force majeure continues to prevent performance up to over 30 days beyond the close, parties can simply cancel the contract. H is conveyance. So the seller will convey marketable title of real property by deed. If personal property is being conveyed, it will be with an absolute bill of sale. So that's going to be like all of the furniture, like specialty lighting fixtures, things like that. We have the closing location, documents, and procedures in I. So location will be where the closing will take place. The closing docs. So the seller will furnish all of their closing docs to the buyer, and the buyer will pay for their lender and the opted documents. And then the FinCEN GTO reporting obligation. So the info must be reported by parties to title to prevent financial crimes. And procedure. The deed gets recorded once all the funds are collected and the closing agent disperses commissions and proceeds. J is the escrow or closing procedure. So this is the period of time between when the original search was run to when closing happens in which a new lien could attach. So an updated search is going to be run the day before closing, but if a lien is missed in that time frame, most title will issue an owner's title insurance policy insuring against it. So no risk will be taken. However, if the title insurer doesn't do this, title will hold all money in escrow and the seller will try to cure it. K is the prorations and credits. So dues will be made current and prorated by the closing date, and that includes taxes, association fees, rents, and advance rent and security deposits. All right, access to the property to conduct appraisals, inspections, and walkthroughs. The seller has to provide access with reasonable notice for the above to be conducted. If a property is damaged before closing, if restoration costs doesn't exceed 1.5% of the purchase price, the cost of restoration will be seller's obligation and closing will proceed. If the restoration isn't completed by closing, 125% of the repair costs will be escrowed and held back, or an extension will happen. If the cost exceeds 1.5% of the price, the buyer agrees to take the property as is with a 1.5% credit, or they can just cancel and get their deposit refunded. So if either party is entered into a 1031 exchange via this transaction, The other party needs to cooperate, but not spend any money on it. And contracts not recorded, persons bound, notice deliver copies, contract execution. This is section O. The contract or any notice of it will not be recorded of public record. All notices must be done in writing via mail, fax, personal delivery, or email. And integration modifications. So no prior agreements are valid if they aren't in this contract. And by closing, the buyer and seller are waiving claims of subsequent found issues previously not known. And then section R, writer's addenda, typewritten or handwritten provisions. So typed or handwritten additional addenda provisions will always prevail over the what's written in this contract. And that's how you will use addendas, basically. S is collection or collected. So collected means that funds have been officially deposited in the closing or escrow agent account. Otherwise, it can be deleted. And then U is the applicable law and venue. So this contract will be interpreted using Florida law, and the venue for dispute resolution will be in the county of the property. We have the FERPTA tax withholding, section V. So if the seller is foreign, the buyer must withhold up to 15% of the seller proceeds and remit it to the IRS, providing proof to the seller after. The title company will do this. However, they aren't party to the contract, so technically it is the buyer's responsibility. And the buyer waiver of claims. This will survive closing. So if the buyer will waive any claims against the seller and real estate licensees for any damage, defects to the property that may exist at closing, but be discovered after closing. And section 19, this is going to be all of the addenda that pertain to this contract. You're going to want to check off all that apply and make sure they are included with the contract. And then additional terms. So here you're going to write anything else that applies. Commissions are going to be done in a separate contract. Please be careful because additional terms are dangerous. You know, we're not attorneys. So before you write anything here, you want to double check with our compliance department and our, your broker just to make sure that it's written correctly. And then line 609 will be where the counter offer box is checked. So if the seller is countering, they should cross out what they want changed and then right beside it the change and then initial the said change. And then, of course, check the box. All right. So the top line about seeking an attorney just reiterates that the buyer or seller should seek advice of an attorney, and everything is negotiable between the buyer and the seller. Line 621 to 630, it covers conveyance to foreign buyers, which is a new law. It's now illegal for buyers associated with a foreign country of concern to buy certain types of property in Florida. So the Florida Land and Title Association has designed temporary forms that can be used until, set forms are created. And, please confirm with the title company that this notice or affidavit, early on in the transaction in case the buyer has questions about their ability to purchase this certain type of property. Deciding whether a buyer is able to purchase property in Florida is not for the real estate agent or the title agent to decide. We're not experts in law. We can only provide the affidavits. If the buyer has questions, they should just seek legal advice. So just a note here about that. Line 631 to 638 is the signatures. So anybody that wants to be on the deed or the title of the property on the buyer's side needs to sign. And for the sellers, anybody currently on title, including a homesteaded spouse, needs to sign. Line 639 to 648 is the brokerage section. And this just lists who is entitled to compensation. you're going to put the specific agent and the brokerage company. We have an info chart here that covers the closing cost assistance, down payments with the different types of loans. Helpful little chart. You might want to just screenshot this or save it on your desktop or on your phone. And that is all I have today for you guys. I'm gonna stop sharing and stop recording and open it up for questions. Here. Yeah, place your questions in the chat or the Q&A. And I just wanted to kind of make a note that we do have a new buyer broker presentation. And so just make sure you guys get signed up for that. I will send all of you guys the buyer broker slides that I made along with these, just because I think you guys probably will want to review that since it's brand new and it deals with all of the changes we're all dealing with in the real estate industry. So I will send both slideshows over to you guys and the recording of this one as well. If you guys want a PDF copy of any slideshow, please let me know. I can't include those in the emails that I send out because it's like too big of a file. So just let me know and I can send that to you separately. All right, guys. Well, if there aren't any questions or comments, please respond back to the email I send you all afterwards. Let me know if you have any more questions. You can always reach me I have my cell phone or which is in my email. My email is mary@daltonwade.com. You can reach out to me anytime and schedule a one-on-one if you want to go over anything. So with that, I will leave you guys all to your probably very busy Monday. I do have dot loop training at 1. Hopefully I will see most of you there. But otherwise, have a wonderful week and I will see you guys all in another training. Bye, everybody.